This is the Mobile Home Park Lawyer Podcast with Ferd Neiman. If you're looking to generate wealth and passive income in the lucrative world of mobile home parks, you're in the right place. You'll discover solutions to the common legal and operational pitfalls and how to optimize parks to maximize income. Your host is in the trenches. He's a real estate attorney, financial analyst, and mobile home park investor and operator. Now, let's turn it over to Ferd Neiman.
Welcome back, Mobile Home Park Nation. Here again today, going through some more legal documents, just trying to keep this thing jazzed up for all you guys. This one I think everybody's going to love because it's something I see a ton of people trying to do. It's assigning a contract or wholesaling, or flipping the paper, or something, whatever you want to call it. Basically, this is when you're going to get a property tied up, meaning under contract, but you do not intend to close it, or you're not planning on closing it yourself. But it's a good enough value, good enough deal that you can add value to somebody else by passing it on to them. And in return, you get paid some sort of fee or commission or piece of equity. How you get paid, there's some that could have some hair on it too, depending on licensure. If you're a broker, if you're a lawyer, if you're not neither of the above, if you're a syndicator, so there's other state and federal regulatory things that could come into play here. So I'm not in this episode advocating you can do this legally, but it happens all the time, and I'll cover some of those that are do's and don'ts and pros and cons in subsequent episodes. But really today the goal is getting you paid on signing the purchase contract. So right out of the gate, obviously, you have to get the contract signed. We've covered the details and the ins and outs in contracts in another episode, but the better the contract form, the better you're going to be able to assign it down the river to the next guy. Key, absolutely number one thing for this process is that contract has to give you the right to assign the property legally. Ideally, I'll have an assignment that says, it won't say my name in there, it'll say Third For Properties, LLC, and or assigns. That's my paper tiger buying entity, my kind of headquarters entity, which owns no property, by the way. So if they ever there's nowhere in the chain of title is some other property owning LLC or my name personally. But that is the ideal verbiage, just blanket ability to assign. If a seller does not want you to assign it, and or if they have competent legal counsel, they may try to limit that assignment to, for example, a related entity managed by Ferd Neiman, basically my special purpose LLC that I'll create for each property. If I'm the actual end buyer, I don't care, it's fine. I don't mind that language. But if my goal is to assign the property, that language is going to make it tough because it'd be harder to assign it to another LLC that I manage. So if I want to assign it to John Smith's going to own 49% of the deal. That may not go well. So the next best watering down for you, the assigner, is to say, Third For Properties and or assigns. Assignment is limited to an LLC or other entity of which Ferd Neiman is a member. Then I could assign it to maybe some bigger operator and say, hey, I need to have 0.1% of the deal. Some small negligible amount, but at least to honestly be saying I'm a member. Frankly, though, this only becomes an issue if the end buyer doesn't close. If the end buyer does close and you are not a member of that LLC, then the actual seller of the property was not really harmed. They got what they wanted. They got somebody to pay them the money. Now, if this is a seller finance deal, it gets hairier. And if it's a seller finance with recourse, it gets even hairier. I recently worked on a case for a client. He received an assignment from somebody else. He was the buyer in this case, the assignee, and he paid, $50,000 or something. But it was a seller finance deal, and there was personal recourse to the guy who tied it up. And the guy who tied it up, I'm sure, thinks when he assigned it to my client that my client took over said recourse. But that's not what the document said. And I was an advocate, in this case, I was representing my client was the end buyer. So, in theory, and in the letter of the paper, letter of the law, if you will, if my client ends up defaulting and does not properly close out and purchase the property, the seller can come after and sue some guy named Todd, who I've never met, talked to, or heard of. But old Todd had a crappy contract and did a crappy job of assignment. So today's lesson: don't be Todd. Okay. First, we've already jumped into how you get the assignment rights. So next, you're going to put this into an assignment contract. I call it assignment of contract for purchase and sale. It's your assignment document. You've got your the parties, who's involved, the date of this consummation of this transaction here. A whereas clause. Whereas clauses will have things like, okay, the subject, property, address, and you got therefore clauses. Therefore, assignor grants, conveys, assigns, transfers, sets over, blah, blah, blah. Assigns the rights. And then typically you want to have, if I'm the assignor and I'm selling it to you, I want to make sure that you have an assumption as the assignee, and what are your actions or duties to perform. Now, as the assignor, I should also have like representations, covenants, warranties, basically say things like, look, I'm telling the truth that I'm actually the, quote, buyer under the purchase contract. That's me. That 34 Properties is my guy, my company. I'm authorized to execute this document. The contract that I've given you a copy of, I'm buying X mobile home park for $1 million. That's actually the real contract, and there's no amendments, except for the amendments that I'm actually disclosing. There's been a First Amendment, a Second Amendment. And then I'm going to reference this to valid purchase contract in full force and effect. I'm not aware of anybody else that's got rights to buy that property, and only the seller and me are the two people involved in the transaction, two people or entities. And then if there's an earnest money deposit or something that I've already put down, let's say I put down $10,000 earnest money, well, I'm going to say I already paid it. And it's going to become your property as the assignee, because as part of my compensation, you're going to give me back my earnest money, so that if you turn into a pumpkin at midnight, I don't lose $10,000. The assignment document should also reference the purchase price of the primary contract. Generally, there's an indemnification provision where if I assign it to you and you end up crapping the bed, I don't have to get sued. And then we'll reference where the earnest money is currently, how much it is, how and when it's released back to me. Let me reference the assignment fee. This is why I'm doing this. This is why I'm assigned, right? I want to get paid. So I'm going to say, how much am I getting paid? How am I getting paid? Typically, the amount is, in the industry, it's, anywhere from typically 2 to 5% of the purchase contract. But if it's a good deal, it's a good deal. I had a nice deal under contract, and my assignment fee was going to be, it was $165,000. But so the deal was $1.3 million. So I don't know what percentage that was, but it was more than 10%. I was going to sign it to this big entity. It ended up, their lawyer got kind of side. Their lawyer goofed and said, I don't like your purchase contract. And I go, what are you talking about? It's good. He goes, well, we can't use it. So we walked away. Well, it turns out the baby lawyer that did that ended up, when the boss got back in town, the boss lawyer's like, no, the contract's good. He just calls it a different word. That's the same thing. Oh, okay. Well, by that time, I was out syndicating, raising money for this, because I wasn't going to be able to get it assigned in time. I don't want to lose my deal. So I ended up syndicating the deal and closing it myself, even though I was originally trying to assign it, because I didn't have enough money, because it needed a bunch of CapEx and I needed like $750K, and I had like 30 days to raise it. Or I didn't have $70K of my own laying around, so I ended up raised it and did a syndication and bought the deal. But anyway, the assignment fee. How much? How do you get paid? Typically, you get paid, at closing, but sometimes you can get paid, and when you get paid is the other thing. You can get paid a portion now, and then where's that portion held? Maybe, if I'm assigning it to you and my total fee is $50,000, I could say I want you to put all $50,000 down and hold it at a title company, but I may not want the seller to know this is going on, or you may not want it to go, so we may just put it in a different title company or different attorney's office, basically in escrow, and then I get it released, quote, released to me at a minimum at closing, but I may put some timelines in there like, hey, after your due diligence period expires, I get it released to me. I may even negotiate and get $10,000 of it released to me now. But you just need to have that clear in your document. So that assignment fee verbiage is the most important piece to protect you. In this case, I'm saying me as the assignor, but also set forth the money piece. And then you got your boilerplate language in the documents, your successors and assigns, no modification, non-partnership, the entire agreement stuff, severability stuff, counterparts. We already covered that in other episodes. And I'm assuming you're listening to all of my episodes, because why wouldn't you, frankly? This is free information. This is like free lawyer stuff. But I'm not your lawyer. I might be your lawyer, actually, but I'm not your lawyer by virtue of giving you this information. So no legal advice was given today. no malpractice coverage is in place, so don't call and sue me. If I'm wrong, which I'm not. I think I've been wrong once. Well, I thought I was wrong, but I wasn't. But because for a minute there I thought I was technically wrong about that. Just kidding. It's an old cheesy dad joke that I heard. All right, back to work here on our assignment document. You want to have a non-circumvention provision. We actually have a whole non-circumvention agreement that we referenced, we covered at a different episode. And then sometimes you want to have the inspection period referenced in here. So if I've got this property under contract and my inspection period for me as the buyer says I have to poop or get off the pot by midnight on December 1, I probably don't want to give you the opportunity to go quite that far. I may say you need to give me 2 days heads up if you bail. That way I can make crystal clear that I can bail properly and get my earnest money back and not get sued from the seller and all that kind of stuff. And we've already covered those terms and releases of money, all that stuff in the underlying purchase contract. So I'm not going to repeat them here. It's also possible. In mobile home parks, the due diligence periods are pretty short. 30 to 60 days is pretty common. I used to do retail development, and those were long due diligence periods because you had to get bids, you had to get civil engineering stuff. Sometimes you get a rezoning, you had to get preliminary development approvals, sometimes tax incentives. So it was not uncommon to have 6-month due diligence. Well, if I was the guy trying to flip the contract, that inspection period is even more important because I may say I'm going to give John Smith the right to buy it, but he's got to commit within the first 3 months. And if he says no, at least I got a little bit more time to try to find John Smith 2.0, who's hopefully my guy. So I still have that provision in my document for MHP work, but it's pretty tough to try to, if the first pony doesn't work, you don't have a lot of time to pick another pony. So choose wisely, and then you got your signature block, basic contract stuff. So anyway, that's the ins and outs, if you will, the fruit, if you will, as well for signing a contract for purchase and sale. Till next time, God bless.
You've been listening to the Mobile Home Park Lawyer Podcast with Ferd Neiman. Ready to learn more? Go to www.themobilehomelawyer.com for free resources and materials to help you succeed. If you love the podcast, go to Apple Podcasts, give us your review, and subscribe today. Thank you for listening. Neither the Supreme Court of Missouri nor the Missouri Bar reviews nor approves certifying organizations or specialist designations. The choice of a lawyer is an important decision and should not be based solely upon advertisements.